Yes, Mr. Pierce, whenever you're
May
ready.
it please the court, may I start with two very short points? My Lord Sir Launcelot Henderson asked yesterday what the implications were of there being different charity law regimes in different provinces.
Different charity law?
Different charity law regimes, the law being different in England and Scotland.
Yes, indeed.
It's a small point, but I can deal with it. If the court would turn to our proposed order, which is in tab 14 of the core bundle. Page 176. In the definitions, charitable purposes are defined as purposes that are exclusively charitable according to the law of England and Wales. And under paragraph 3, the trusts are to apply the trust fund for charitable purposes within the United Kingdom. So the definition of charitable purposes makes it clear that the purposes for which the fund is applicable throughout the United Kingdom are purposes which are charitable under the law of England and Wales. I hope that resolves that point. The second preliminary point is this. The court asked my learned friend yesterday, and I'm reading from the note, whether it made a difference to the respect the court pays to the views of the attorney, that she is where the beneficiary is the government of which the Attorney General is a member. And the answer given was no. A correct answer to that question would, in my submission, be this. It does make a difference in this sense that the attorney is in a position of conflict, which does not usually arise in charity cases. But it is a conflict which is authorised by our Constitution. And therefore it is for the attorney to manage that conflict. And the court will doubtless assume that she has done so. And we, for our part, do not take any point about the attorney's conduct of this litigation. A third, moving on to more substantive points, a submission was made by reference to the case of Strakosch to the effect that the trust deed can't be construed as a gift for charitable purposes for the benefit of the United Kingdom, or in those terms, with similar terms. But we entirely agree. We don't submit that the trust deed can be construed as creating a trust for general charitable purposes in the United Kingdom. That is, if I may respectfully say so, a red herring. We say that those are the trusts that should be ordered by way of scheme following the failure of the trusts and the trust deed. There was discussion about the evidence that's admissible to determine the spirit of the gift. The test, which one derives from Varsani and Dasani, is that the spirit of the gift is to be ascertained by reference to relevant evidence as to the circumstances in which the gift was made. And although there were submissions made by reference to the penumbra of the gift, in my submission there has been no real attempt to show that the approach that we have adopted of confining our submissions to the documents relied on by the judge was not the correct approach to take. So those submissions, as far as they were pursued, go nowhere in our submission. Turning to the question of what is the spirit of the gift, my Lord Sir Launcelot Henderson observed this morning that the documents which the court has been taken to show a consistent picture. He didn't go on to say what that consistent picture was, so perhaps I may make a submission about it. Essentially what they show is that the donor made a gift to the nation for the purpose of discharging the national debt, and the elements of the gift being to the nation and being intended to encourage others to do likewise are strongly present in the documentation. My Lord, I don't anticipate that putting the matter in that way is likely to be very controversial. And obviously the court has our submissions that, based on the documentation and the terms of the trustee, and applying to those the definition or description of spirit of the gift in Valsali and Giussani, the natural conclusion to draw is that the spirit of the gift contained the two limbs for which we contend: to benefit the nation without restriction to matters to do with the national debt, and to encourage altruism in others. The court has our submissions on those points, and I don't propose to, it would be wrong for me to try to repeat them. There was discussion this morning about whether the spirit of the gift needs to be wider than the purpose, and the learned judge's formulation of the spirit of the gift comes very close, we say, to being simply a paraphrase of the purpose, and therefore the question whether the spirit of the gift needs to be wider than the purpose does, on his approach, does arise. The answer in our submission is this: if one has a case where the spirit of the gift is coextensive with the purpose or doesn't go beyond it, then a correct application of paragraph C may well result in a purpose being created by way of scheme that is not within the spirit of the gift. There's nothing in section 67.3 that says that any new purpose must be within the spirit of the gift. The spirit of the gift is a matter to which the court is to have regard. But if the spirit of the gift is so narrow that it does not, if you like, foster a purpose which satisfies paragraph C, then because of the terms of paragraph C, and I might say a more general common sense approach, having regard to what is the basic intention of the cy-près doctrine, lead to the conclusion that you may well end up with a purpose that is outside the ambit of the spirit of the gift.
Well, I think that argument really goes as follows, doesn't it? The starting point for section 67 is a failure of the purpose. If the spirit of the gift is no wider than the failed purpose, then paragraph C must empower the court or the commission to make a scheme which is not in accordance with the original spirit of the gift.
My Lord, precisely. So, in a sense, whilst we say that the spirit of the gift is, as I've summarised the matter, and it supports our scheme, it doesn't actually matter at the end of the day, having regard to what we say about paragraph C, whether that's right or wrong. Because you cannot, on our submissions about paragraph C, end up with a new purpose which is not suitable and effective in the light of current social and economic circumstances.
But here, the judge has, as it were, occupied the middle ground. He said, yes, the spirit of the gift is wider than the failed purpose, which was to discharge the national debt. But within the spirit is reducing the national debt, and the spirit does not go wider than that. In other words, yes, it was to the gift was to benefit the nation, but to do so in a particular way.
Yes. Well, if that is the right approach, my submission still holds good. A purpose of applying the trust fund in reduction of the national debt, for reasons I've submitted, is not suitable and effective in the light of current social and economic circumstances. So one ends up, the same argument which Your Lordship has postulated applies equally if you start from the middle ground that Your Lordship has described Mr Justice Zacaroli as having occupied. The way we put it, as the court will recall, is that paragraph C points overwhelmingly or conclusively, I forget which particular adverb we used, in favour of our scheme, a fortiori, when combined with paragraphs A and B. So we say that paragraph C gets us to our scheme on its own, and if paragraphs A and B point in the same direction, so much the better.
Yes.
My Lord, a submission was made about the relationship between the spirit of the gift and our proposed scheme, which I noted down in the following terms. I think that what was submitted was that the appellant suggests that the reference to the nation gives rise to an implication that the intention is to benefit the nation as a whole by way of general charitable purposes. So I think the submission that was made was that by identifying the spirit of the gift as being a gift to the nation, we are in some way imputing to the settlor an intention that his gift will benefit the nation by way of being applied for general charitable purposes. If I've got it wrong, I'm sorry, but that's what I thought the submission was. If that is the submission, we would say it's not a correct reflection of our argument. Our argument is simply that the spirit of the gift is to benefit the nation without limitation, and that a trust for general charitable purposes for the benefit of the nation is within that spirit. We are not saying that the intention of the settlor was in some way subliminally to create a trust for general charitable purposes. It wasn't. The spirit of his gift was simply to benefit the nation, and the scheme that we propose fits well within that spirit. And my Lord, that's what we say about that submission. Our submission and my Lord Justice Lewison's observations yesterday about the relationship between the spirit of the gift and general charitable intention have given rise to a certain amount of debate this morning. We have always, on this side of the court, been anxious not to get drawn into that topic too deeply. The way we put it is as we put in our skeleton, which is that it is the way the learned judge approached the question of general charitable intention is more consistent with our formulation of the spirit of the gift than my learned friends, because in his discussion of whether there was a general charitable intention, he leans very strongly in favour of this being essentially a gift to the nation, although he
I
doesn't
thought that
go
what you
quite
were
that
saying
far.
yesterday, in effect, was the judge made a finding of fact about Mr Farrer's intention. And the finding doesn't change according to the nature of the
Yes.
question you ask.
Yes, well, my lord, that's right. But if one looks at the way in which he concludes that there is a general charitable intention, his approach is more consistent with our approach than the attorneys. That's as far as I want to take it, because otherwise one does risk confusion because the concepts are different. My lord, turning to the second limb of our formulation of the spirit of the gift, by setting an example to encourage altruism in others, in our submission, nothing has really been said to detract from the force of our arguments on that point. Obviously, what the settlor was doing was seeking to encourage others specifically to contribute to the eventual discharge of the national debt. That is quite clear. But the spirit in which he did that was one which can be drawn upon in contexts where his original purpose has failed. And the learned judge, as I submitted yesterday, has gone down a blind alley by framing the question as similar to what? That's not the question. The question is, what is the spirit in which the settlor tried to stimulate that activity amongst others? And it was the spirit of seeking to encourage altruism in others, seeking to encourage others to spend their money for the benefit of the nation. My lord, turning now to paragraph B, our overriding response to my friend's submissions on that is to ask the court to construe the section. It is desirable that the new purposes should be close to the original purposes, and in the context of this area of the law, close is a deliberate, we say, advance or retreat, whichever way you look at it, from as close as possible. And general charitable purposes are close. General charitable purposes within the United Kingdom are close to a purpose of discharging the national debt, because both benefit the whole country. Now, I think yesterday an attempt may have been made to try to deflect that point by demonstrating that the discharge of the national debt, the reduction of the national debt, come within paragraph M of the list of descriptions of purposes in the Charities Act. And if you say general charitable purposes, you are including everything else in that list. That is quite true, but that is the right approach if you are trying to think of what is close to the failed purpose of discharging the national debt. It is what is charitable and what is for the benefit of the whole country. The law provides a definition of what is charitable under English law, and it's the right course to adopt that as the alternative. And it doesn't really advance matters to think of far-flung ways in which trust fund could be applied, one can immediately see that there are certain purposes in that list of descriptions of purposes that are unlikely to appeal to a trustee of this trust. But it will be wrong to try to go through that list and cross things out. The right approach, as I submitted yesterday, is to ensure that you have put in place the right trustee body to make the right judgments. And you are needlessly complicating their task if you start picking things and saying, well, you're never going to want to do that, let's cross that out, and so on and so forth. That approach, as far as it's being advanced, and that's not the way my own friend put it, but that's perhaps where his submissions were going, that approach misunderstands, were it to be his submission, the strength of a discretionary trust with suitably qualified trustees. They have a broad discretion, but they are to be relied upon to exercise it appropriately.
It's placing a lot of weight, though, isn't it, on the advisory board and the independent directors. I mean, in theory, they could, I don't know, divide the fund into two and give half of it to the University of Oxford and half of it to the University of Cambridge, and that's
my lord, they
only
could.
Benefits the nation in a very indirect sense.
My lord, they could, but that is, if I may respectfully say so, not doing justice to the good sense of our proposal. It is implicit in our proposal that the trustees will be selected, I don't need to go too many details, but by a properly managed recruitment process. They will be submitted to the court for approval. The advisory board will be constituted to make sure that they have the benefit of advice from all relevant directions. And there can be no doubt that the activities of this trust, if it's set up in the way we describe, will be a matter of intense interest, if not throughout the nation, and certainly within the charity sector. Its activities will be very closely scrutinised, and you need trustees who are of a calibre to make decisions that will command respect and to be able to defend and explain those decisions to an interested audience. In a sense, of course, your lordship is right. It is putting a lot of weight on them, but that is the right approach. My lord, just by way of a slight deviation, Sir Stephen Bubb, in his opinion, in his advice, gives examples of other large grant-making charities.
This is the Gatsby Fund and all that.
Yes,
Yeah.
well, that was exactly the one I was going to mention. The Gatsby Fund he cites, it seems to be of a similar size to what this fund would be. Its purposes are, he quotes them, general charitable purposes. He explains that it has, in fact, focused on a particular area of activity, which I think is medical research. But there's nothing novel about having a grant-making trust with general charitable purposes. He gives that one example. The others that he enumerates in his report, it's not so clear what their purposes are.
He talks about Wolfson Foundation and
yes,
another foundation as well.
So, but the point one gets from reading his report is that there is within the third sector, as it's called, expertise in running grant-making charities with wide objects. It's not something that is done from people's kitchen tables. It is a I was going to say a profession, it's a specialism which exists, which can be harnessed to operate this charity. And as I've already submitted, there can be no doubt that the people who are appointed to do so will be held to the very highest standards by the audience or the community that will be interested in what they're doing.
Not to mention by their regulator, the Charity Commission.
Yes, precisely. And
referring to taking interest in
indeed, well,
various charities get up to.
the Charity Commission, as my Lord Launcelot Henderson knows, occupies or applies a risk-based approach to regulation. One would like to think that this would not be categorized as a high-risk charity. It will be, in their terms, a low-risk charity because it will be administered by people of the highest caliber, and its activities will be transparent and will be intensely scrutinized by lots of people other than the Charity Commission. But my Lord is of course right, the Charity Commission is there to exercise oversight. But I wouldn't like it to be thought that what we're saying is that what will keep this charity on the rails is the fear of being brought to task by the Charity Commission. It will be kept on
I
the
didn't
rails.
mean to suggest that at all, but I mean, it's
Yes.
just, the point is that the close interest in the affairs of a charity don't necessarily come from the wider public. They may come
Yes, yes,
just as much from the charity sector itself, including
Yes.
its regulator.
yes. So in my respectful submission, the court has nothing to fear from the concept of our scheme. It has been put together by people who are well qualified to do so. And as I've already indicated, we would welcome any observations the attorney has to make on it, assuming the court were to allow the appeal. And we have been careful not to do anything to close the door on,
Yes.
on her. So if I may now move on to paragraph C. My learned friend yesterday, and I think today as well, continued to support the explanation given by the judge at paragraph 58 of J2 for the word need. If I could just remind the court of what that is.
To avoid another cy-près event.
Yes, that is, sorry, if I just may take a moment to get it in front of me.
It's paragraph 58.
I'm grateful, yes, paragraph 58 of J2. He states that the word need is explained by the matter to which my Lord has just referred. My Lord, that is the first point is that the court has to construe the section as it stands, and you cannot construe it as being constructed so that the word need serves so limited a purpose. But that explanation is also historically incorrect, and to explain why that is so, may I ask the court to look at something we haven't gone to yet, which is the annual report of the Charity Commission for the year 1989, which is at tab 47 of the second authorities bundle. The text starts at page 1039 a fund. And the court sees that at page 1039, paragraph 72, halfway down the page, halfway down the paragraph, in making schemes, we exercise the same functions as the courts. We are concerned to provide an expert and authoritative service to trustees, responsive to the needs of each charity, and to act in a way which is both flexible and imaginative. Many of these cases are complex and demanding. And then in paragraph 73 over the page, they explain that they're reproducing some of the guidance that they have given to their staff. In paragraph 74, the application of the cy-près doctrine is a legal process involving the establishment of a scheme. The determination of the new purposes to be conferred is essentially a practical issue in which usefulness and practicality, as well as proximity to the existing trust, must be taken into account. In determining the appropriate cy-près application, regard must first be had to the trusts of the charity. With these in mind, the nearest practicable charitable purpose needs to be ascertained. Consideration must be given to whether the purpose is suitable and effective, bearing in mind the situation of the charity in the community and the needs of the community. If the view is taken that the nearest practical purpose is not suitable or effective, then other purposes may be selected. To choose a purpose which may be the nearest practicable purpose to the original purposes of the charity, which is already adequately provided for which cannot provide a suitable and effective method of using the charity's property, would be to impose purposes which will already have failed within the circumstances laid down in section 13 of the Charities Act. And examples are given. And perhaps I can just read on while we're still looking at this document. In paragraph 75, in determining the new purposes, it is essential not to erect artificial barriers to a flexible use of the doctrine. And there is discussion of whether the new purposes must be selected from within the same category as the McNaughton fourfold classification, to which the answer given is no. And then on page 1041, they say, in relation to Roman numeral 5, the idea that certain elements of trust are sacrosanct, for instance, the age limit included in educational schemes, religious qualifications, in essentially secular charities, qualifications, or sex qualifications, particularly in religious schools, we take the view that no part of a charity's trusts is unalterable. So that was the Charity Commission's policy in 1989. And the reason I take the court to it is that it squarely identifies that a new purpose, in terms of paragraph 74, must not be one which will already have failed within the circumstances laid down in section 13 of the Charities Act, which is essentially the submission made by my learned friend and accepted by the judge as to why paragraph C is there. A moment's thought shows that from a purely historical point of view, that cannot be the reason why paragraph C is there. The only people who make schemes are the court and the Charity Commission. The Charity Commission had in 1989, and obviously before that as well, a policy which plainly flagged up the, I'm trying to avoid the word need, the importance of not creating purposes which would, as it were, self-destruct. The courts, who usually act on the recommendation of the Attorney General, will know better in any event. So there would have been no purpose whatsoever in enacting as part of the 2006 Charities Act something which the regulator already had as part of its policy, and which the courts can be expected to have been able to work out for themselves is the wrong thing to do. So that explanation for why paragraph C is there simply fails as a matter of history, and one should, in my submission, adopt the far more obvious and straightforward explanation for paragraph C, which is that Parliament thought it was important that when a charity is given new purposes by an exercise of the cy-près jurisdiction, those purposes were suitable and effective in the light of current social economic circumstances, because the whole purpose of the cy-près jurisdiction is to give new life to a charity which has died or is dying, and that must be done in such a way as to ensure that charitable assets are used in the best possible way. And that is what paragraph C is there to do. And you cannot, in our submission, marginalise it or read it down by reference to an objective which the regulator had already fully directed itself about. One has to apply paragraph C without any predisposition to read it down and marginalise it. My then friend's submissions this morning, in our submission, failed to engage with the question which we pose in our skeleton argument: suitable and effective for what? Or, as far as those submissions did engage with it, the answer was to the effect that suitable and effective for a charity of the description which the scheme maker is considering. In making that submission, my friend is departing from the approach which Mr Justice Zacaroli adopted in J3, where he made clear that he had interpreted paragraph C as being as saying suitable and effective in providing charitable benefits. That is the implication that he clarified in paragraph 3 that he had made. There is therefore a clear difference between us and the attorney over what the new purposes have to be suitable and effective for. The attorney's submission is that they have to be suitable, that their suitability and effectiveness has to be gauged by reference to the charity which the scheme maker is concerned with. We say, and I don't intend to repeat our submission, we say that suitability and effectiveness has to be assessed in its own terms, and that the question of whether, and therefore that the new purposes for the charity have to be selected from purposes which are suitable and effective in the light of current social and economic circumstances. And the task of selecting between purposes which qualify on that basis is to be performed by reference to paragraphs A and B. But you must start with purposes which are suitable and effective in the light of current social economic circumstances in their own right. You cannot water that down by saying, well, this purpose is suitable and effective for a charity which was set up to do some particular thing, and that is obviously right because the charity has ex hypothesi failed.
So does that come to really saying that what the court must ask itself is, what's the best use of this money? Here's a fund, it's a very big fund, it can't pay off the national debt. What's the best use to which it can be put?
That is a very, very simple.
I like things simple.
It's a very simple distillation of what we are essentially saying, but it is not simply, and I'm sure Your Lordship is not suggesting it, it's not simply a matter of the court coming up with what it thinks is the best use. There is a structure to the section.
Certainly.
But it is important in our submission that we say paragraph C is central to this new jurisdiction, because the new purposes there is a need for them to be suitable and effective in the light of current social and economic circumstances in providing charitable benefits. That is an essential part of any scheme, as the word need.
Yes, but charitable benefits, obviously not restricted to, but certainly include reducing the national debt.
Yes.
Which is an odd anomaly in charity law. It seems odd to me, at any rate, that if a gift for government purposes is not charitable, and the effect of a gift reducing a national debt is to free up money for government purposes, it seems odd to me that one is charitable and the other one is not, but that's the law.
My Lord, it is anomalous, but if one tries to apply logic remorselessly to the categories of purposes which are charitable and which are not, that would be madness.
So paying down the national debt by however much is a charitable purpose. I think we have to accept that. So to ask whether the fund would be suitable and effective for providing charitable purposes must at least encompass paying down the national debt.
Yes. It is an eligible...
So does your point really come to the judge in effect asking himself, well, given the size of the national debt today, this is a really daft thing to do?
Well, again, accepting my Lord's invitation to embrace simplicity, yes, that is a dramatic way of encapsulating what we're saying. If I can approach it perhaps by stages, my Lord Launcelot Henderson said yesterday that at one point the audit trail ends when the money is paid over to the National Debt Commissioners, and my friend Mr. William Henderson made a similar point yesterday and today when he said it's not an objection to what we are asking for, that the money disappears. Of course it disappears. It passes out of the realm of charity. It goes to the National Debt Commissioners in the same way as money disappears if you spend it on providing clothing for a poor man. But that is to try to gloss over the fundamental weakness of the attorney's scheme by saying, well, the money is going to disappear anyway, and that is not an objection, misses the fundamental point that you have to ask what good is done by disposing of the money in that way. In the case of the poor man, the money disappears, but you have got in exchange clothing and food for the poor man, which relieves his needs. So at the end of the day, good has been done.
And you read that into suitable and effective?
Suitable and effective in providing charitable benefits. You'll have to read something into the section. One has to say, The section doesn't say suitable and effective for what, but in order to understand it, one has to work out.
It's a charitable purpose that's suitable and effective. Yes. Charity has to have purposes which are suitable and effective.
Yes, but suitable and effective, we submit that you have to ask suitable and effective for what? Is it for reflecting as closely as possible what the original donors would have wanted to happen? No, it's not. Is it for giving effect to the spirit of the gift as closely as possible? No, it's not. It is for providing charitable benefits, suitable and effective for providing charitable benefits, because the cy-près doctrine is concerned with giving charities a new lease of life so they can continue to provide public benefit. And the only way, that is the underlying context in which this jurisdiction is being exercised. And it must therefore be the case that when the section asks for a purpose to be suitable and effective, it's saying suitable and effective in the light of current social and economic circumstances in providing charitable benefits today. And I suppose in the future as well. So it's not enough simply to identify that a proposed application of the fund is a charitable purpose. As I submitted yesterday by reference to Camden's charities, the legal landscape is littered with charitable purposes that are still charitable purposes, but are now no longer suitable or effective so as to be eligible for selection for inclusion in a scheme. My Lord Justice Lewison referred yesterday to the preamble to the Statute of Elizabeth, and I couldn't say whether apprenticeships were within it. There are one or two things in it that are close to apprenticeships, but if one were to read that preamble, everything in it would still be a charitable purpose, however quaint that they would seem, but they would no longer be appropriate for selection because times have changed and they're no longer a suitable and effective way of providing charitable benefits. And the same is true of this purpose, reducing the national debt. It is still a charitable purpose. It's not harmful in such a way as would cause it to cease to be a charitable purpose, in the same way that the abolition of this section was held to be harmful and therefore be disqualified from being a charitable purpose. It is a charitable purpose, but it's not an appropriate one to select applying the criterion in paragraph C, because if I can venture to use my Lord's dramatic encapsulation argument, it's a waste of money. Something which produces a reduction in government interest payments of £5.6 million a year in circumstances where government expenditure in 2021 to 22 was £1,045 billion, achieves nothing, and we maintain this position, achieves nothing because nothing changes. No new activities are financed by the state, no taxes are cut, nothing changes. So the money does disappear, except as a book entry, in a real sense, and that is not, that it disappears because although it passes from one hand to another, it doesn't actually do anything practical, nothing changes except a book entry or a spreadsheet.
Yeah.
My own friend says, well, it's ridiculous to say that to give £500 million is doing nothing, but £500 million is nothing. But the the answer to that is that the attorney has, and I don't mean this disrespectfully, alighted upon the one way of applying charitable property which achieves absolutely nothing. I literally cannot submit to the court any other purpose which so dramatically causes £500 million to disappear without trace. How is that is effectively what her scheme does. And obviously £500 million is a huge amount of money, and that's why we have put together a scheme to enable it to do much good. But the attorney's scheme results in it doing nothing whatsoever. My learned friend cannot point to anything that would change. He mentioned vaguely this morning what might result from hypothecation, and it is correct that were it to be hypothecated to primary school children, there will be an additional £1 or £2 per child, and obviously any head teacher of any school would say that was very welcome and would make good use of it. But the point is that that isn't going to happen, because there's no evidence of that and no reason to suppose it will happen. It will just disappear into the general deficit, general budget balance deficit, or it will just adjust that slightly. But the result of adjusting it is that nothing changes. My own friend cannot have it both ways. He can't say, well, if it were hypothecated, it would do good. But then equally say, as I accepted yesterday, he's fully entitled to do, make no criticism, that there is no hypothecation in evidence. So it is. I'm sorry, my lord.
I'm so sorry. No, please finish your sentence. I was going to make an observation, which is in many contexts, one comes across dicta to the effect that the court shouldn't make orders in vain or really make an order which is futile or impossible to carry out. Are we in that kind of area at all? I mean, are you, from one point of view, the burden of your submission is just an exercise in futility to make a scheme in these terms, because it, as you say, it produces nothing except book entries with no real effects in the real world on anybody's life or activities or anything else. And that's a rhetorical way of putting it, but is that perhaps another way of encapsulating the thrust of your point?
My lord, it is. We submitted, and the learned judge quotes this in J2, we submitted at the scheme hearing that the attorney's scheme or the application of the trust fund in accordance with this scheme is a futile symbolic gesture.
Yes.
That's what it is. It is futile because nothing changes. It is symbolic because it is not real. It is an extraordinary state of affairs, and in my submission one has to attune one's mind to the magnitude of the sums that are involved here. The National Fund itself is a huge fund, but the national debt is so huge that it's simply beyond our comprehension in terms of finances that one deals with in any other context.
Well, and the scope of state spending has changed dramatically since 1928.
Yes.
It's with the creation of the welfare state.
Of course, yes. And I hope if the court has time to do so, it will look again at those parts of Professor Ellison's report in particular, where he describes changing attitudes to the national. In the 1920s, there was an aspiration, as I said yesterday, amongst Mr. Churchill and others, that it would be repaid. Nobody, except applying what Professor Ellison calls I think it's the monkey Shakespeare theory, that you can generate. Does the court know what I'm referring to when I say
Yes.
that? You can generate hypothetical situations in which the national debt might disappear.
Well, there was a slight disagreement, wasn't there, between Professor Ellison and Professor Portis on attitudes. Professor Portis thought that some people in the Treasury were quite keen on paying off the national debt, And I think Professor Ellison said yes, but not quickly.
Yes.
Was to that effect.
Yes. Well, my lord,
I think that's in their second statement.
my lord, I think that is right, and I'm not going to trespass on their expertise, but it may well be that in a world where interest rates are lower than inflation, the national debt kind of withers away just by virtue of disparity between those two concepts, and that is something which people look at with approval and pleasure. But the national debt is a permanent feature of the national economy in a way that it perhaps wasn't seen as being in the 1920s. And whilst I want to make it clear, I'm not suggesting that it's a bad idea to reduce it. I'm just saying that things have reached the point where even £500 million in relation to the national debt is such a tiny amount of money that applying the one to the other makes no practical difference whatsoever. It is, as I've my own friend, as I said in our submissions to Mr Justice Zacaroli, it is a futile symbolic gesture, and it is not something which the court should be doing by way of a redirection of charitable funds in exercise of jurisdiction, the purpose of which is to ensure that charitable funds continue to provide real public benefit, not theoretical or symbolic public benefit, but real public benefit by way of improving something for the objects of some charity. Although I think I've taken full advantage of my ability to reply, probably excessively so. Unless there's anything else I can help the court with, those are my submissions.
Thank you, Mr. Pearce. Well, very interesting case, a lot to think about. So it won't surprise you to learn that we will reserve our judgments. You will get a draft in the usual way. This will be your chance to correct our English but not our reasoning. We would hope that in the light of the draft judgments you will be able to agree in order. If you can't agree in order, please make short submissions in writing on the form of the order, and we will make the order in the form we consider to be appropriate. The hand down, when it eventually comes, will be electronic, so nobody needs to attend. Thank you very much.